Yes.
Item number 1.
You said there was no admission matter? How it appeared in the list? Suddenly? Late filing? I asked you, you said there is no admission matter. Yes.
For the respondent, my lord, respondent district council, this is a matter, my lord, related to NOCMA appointment, where the petitioner had challenged the appointment of the private respondent, my lord.
Here, substitution by granting leave to the applicants to prefer the appeal with retrospective effect and on the register is very applicable. Is disposed of. There is no direction for listing of the appeal. Not mistake. You told me yesterday there's nothing for admission. The appeal has been granted a number. Appeal is filed. What is the number? What she? We can say since our order the appeal has been filed and numbered so and so registered as. Please take down. Reference may be made to our order dated 26th November 2024. The order has been given effect to next line and the appeal filed, registered and numbered as WA/40/24. Paragraph. It is listed today for admission. None appears for the appellants. Though the respondents, you are representing all the respondents?
No, my lord. Respondent 1 to 4, I am representing.
1 to 4 are represented by learned counsel. List this appeal once again in the same position on 24th March.
Number 2. May I please, Your Lordship? Your Lordship, I had already received the affidavit of respondent number 7, Your Lordship.
May I please, Your Lordship?
Yes.
Senior Counsel, Additional Advocate General Mr. Khan was sick, so he had to go. And our affidavit is ready. We'll be filing during the course of the day, my lord.
But for respondent number 7, I have filed that.
This is
in fact, nothing.
objections as recorded in the order dated 7th March.
Yes, ma'am, I have filed. For the contractor.
For the
Contractor. Private
It has been filed.
and you will file it for?
My lord, we have already filed through the registry, my lord. But Senior Counsel is unavailable today, my lord, because of his personal.
What is this litigation about? Private
My
litigation?
lord, here what happened, my lord? Contract for construction of a stadium in Tura, my lord, in Garwell, was awarded to us, my lord. And there was a heavy flood, my lord, on a particular day. So a temporary boundary wall that was, Lordship kindly comes to page 9 of my affidavit, my lord. With the pictures are annexed, my lord.
We will take it up on Monday. What is it?
And that has been, we have reconstructed the wall, my lord. The matter, nothing remains, yes, sir, ma'am. Page 9 was the demolished wall, my lord, and page 11, Lordship will see, we have reconstructed the wall, RCC wall, my lord.
The project has been, the stadium has been constructed.
My lord, some part is still left, my lord, because there are badminton courts, there are gym. So
Where is this stadium?
in Garwell, my lord, in Tura.
So when should we take it up?
Monday, my lord.
Let them just file their affidavit, Your Lordship, and after that we filed the rejoinder, Your
We have
Lordship.
already filed.
No, respondent number 3 to 5 haven't filed. I haven't received the.
State has done, but the state will reiterate the same thing, my lord. It was only a temporary wall at the time of construction, my lord, that fell down and we have reconstructed it. So Monday, my lord.
No, the order says time to file objections in terms of our earlier orders is peremptorily extended till 13th March. Who have not filed? 7, respondent number 7.
I have filed, my lord. The state has not filed, my lord.
Lordship 345, Lordship, the affidavits processing, Lordship, or you send it to
Filing section.
And 1 and 2.
What is the former party?
Sorry,
We are the former party. We are not.
you have filed.
No, we are the former party. Yes.
Pro forma parties. All right. List this public interest litigation on when those matters are fixed, specially fixed matters, any matter, 25th, 26th, 27th, 26th.
So 3 consecutive days, my lord, 26, 27, 28 matters are fixed, my lord.
This month or next month?
This one.
Then 25th.
25th.
Time to file objections in terms of our earlier orders is further extended till 24th March. Much. Was the matter fixed at 12:30? Item number 3, 4, 5 and 6. Yes. Please record separate orders.
Lordship, kindly please allow 2 weeks.
Monday it will be taken.
Lordship, item number 3, Lordship may have it after 2 weeks because now it is for hearing, for final hearing.
So, but it is, who's on the other side?
The other side is no longer the contractor.
No, no, in the absence of the other side, we are keeping it on Monday. They will pray for adjournment.
Yes.
3, 4, 5, 6, separate orders. As the appeal as another appeal is specially fixed and likely to continue. For the rest of the day. This appeal is adjourned for the day and shall appear in the list on. This appeal is adjourned and shall appear in the list on 24th. 3, 4, 5, 6. Separate orders.
May I please, Your Lordship, for item number 5, Your Lordship, I'm praying for first week of April, Your Lordship. For item number 5, I'm praying for first week of April, Your Lordship.
You pray it on Monday. Today your other side is not there. It is just
Lordship, other
posted.
side is there, Your Lordship.
No more. Please plug the list.
Item number 7.
Please, Your Honor. My lords, Mr. N. Venkatraman is joining momentarily. I
Sorry?
understand my lords have discharged. Mr. N. Venkatraman, senior advocate, is joining momentarily. He's on his legs, but we understand that this honorable court has kept this matter specifically. With the permission, I would like to start.
Please do.
I'm very grateful. My lords, there are 4 main points, as we understand, that have been raised by the learned Advocate General.
Yes.
The first point is a point which we would say possibly procedural in nature, which is to say that the demand notice that was impugned of 12th June 2023 was only addressed to respondent number 4, and that therefore the petitioner in the matter, that is respondent number 1 today before you, is not competent to challenge that demand. My lords, to answer that point straight away, may I take this honorable court to the prayers that have been sought in the
Yes.
petition, in the writ petition.
Yes.
My lords would have that at page 106.
Yes. Carry on, please.
Yes. My lords, please see the prayers at page 106.
Yes. Yes. Please proceed. We are
Yes,
better
sir.
off hearing you. You read the prayers, we will hear you.
Yes, my lord. My lord,
Yes.
the first prayer that was sought by us was with respect to a declaratory relief, which is to say that issue a writ in the nature of mandamus to abide by the provisions of section 31(1) of the Insolvency Code. And I will take the honorable court to section 31(1). But the second prayer is equally important. Declare that the approved resolution plan is binding and petitioners are not liable to pay any debts, claims or dues prior to 22nd December 2022 to respondent number 2. And then, my lord, is prayer C, which the learned advocate general referred to, which is with respect to the demand notice. It is our submission, my lords, that prayer C, for which much has been made, is more of an ancillary prayer. My primary relief in the petition was a declaratory relief that no debts whatsoever in the name of the petitioner, that is respondent number 1 before you, are liable to be paid in view of the provisions of the insolvency code and the approved resolution plan. In order to seek that declaratory relief, it is our submission that it was the petitioner was perfectly entitled to seek that. And the answer and the reason why, my lords, is because the state, that is the electricity company, sought to recover from respondent number 3 and 4 the dues of the petitioner. So if this honorable court, and like the single judge did, allowed prayer number A and B also, then the question of challenging C also does not arise as moot, because the learned single judge has allowed my prayer A and B and held that the debt stands extinguished in accordance with law. That, my lord, is my submission as regards the procedural issue raised by the learned advocate general as to the maintainability of the petition before the learned single judge. If my lords have no further queries on this, may I move to the second point?
The consumption was made by whom? Of the,
Very grateful. The consumption was made by the petitioner. And my lords, this is extremely important because on the one hand, the learned advocate general points out that respondent 3 and 4 are separate entities from the petitioner, and hence the petitioner cannot bring up a challenge. But it also applies the other way around. The state cannot seek electricity dues of the petitioner against respondent 3 and 4. It is completely an anathema to the principle of separate legal personality. There is no provision in law, either under the Electricity Act or otherwise, to seek dues of one corporate legal entity from another. I could understand lifting the corporate view.
But those terms and conditions which were being placed, I think subject to correction of that agreement of users, etc., that it was the option was there either to seek it from the petitioner or from the ultimate user. You come
I'm
to
very
this,
grateful, but we are neither the ultimate user nor the respondent number 3 and 4 were neither the ultimate user nor the petitioner. It was very clear, my lord, and in fact, nothing to that extent. There was no dispute before the learned single judge, and I'm great. If even today we believe there's no dispute that these dues are of the petitioner that are sought to be recovered from respondent 3 and 4. We have made a categorical statement, even including in our petition, if any dues as user are to be conferred on respondent number 3 and 4 as users, then we will pay it up. In fact, as it was shown in the hearing previous to the last hearing, the learned single judge had asked the state to file an affidavit to this effect as to who are the dues to be, who is the user of these dues and who has actually incurred these charges. That affidavit still has not been filed because they cannot say that these dues belong to respondent 3 and 4. We actually thought till the matter came up in appeal and the learned AG argued that this was one of the questions that was not even disputed. In order to further aid my submission, may I please show once again the demand notice, which is at page 106. Sorry, 109, my lords. Would my lords have that? My lords will see the annexure issued to this demand notice is issued to respondent number 4, and my lords may see very clearly in the address point itself a subsidiary of respondent Reliance Jio. My lords, there is no relationship of holding company, subsidiary company between respondent number 4 and the petitioner. That is also a word in the petition. But more importantly, my lord, may please see the annexure from page 110 onwards. All these towers belong to Reliance Telecom, which is the petitioner today. So they are seeking, even according to them, the user, and the consumption is by the petitioner. And in order to further take this, my lord, may I please request the honorable bench to have page 358 of the petition. It's something that was very perplexing, so I'd like to refer to it at page 358.
Now you come to this bill, annexures to the bill at 110 and 111.
I'm
There
very
is a
grateful.
Third last column, there is a reference to tower company.
I'm very grateful.
Now this tower company, all Reliance.
Reliance Telecom,
Now-
which is the petitioner.
It has no connection with this 3 and 4. Is the-
Reliance Telecom is not related to 3 and 4. Reliance Telecom is a separate Reliance entity. If I may give the genesis, my lord, it was a company belonging to Anil Ambani.
No, just
Reliance.
Mr. Advocate General,
Yes, Your Lordship.
just seeking a clarification.
Yes, Your Lordship, is-
What is the relationship between this?
the relationship which has been described in petition, my lord, if Your Lordship will see.
No, what is the relationship as per your notice?
My notice is, my lord, that the Summit Digital Infrastructure has applied for connection. If Your Lordship will see, that letter itself is very clear, 109. It has applied for connection. And
109.
yes, my lord. And then we have denied the electricity connection on the ground that outstanding are dues against these towers, because the connections are in respect of those towers only, my lord.
No, but who's the consumer?
Now, right now, consumer for me is, earlier my friend is right, my lord. Earlier my friend is right. Reliance Infratel may be consumer. That is not very clear from the writ petition, but to that extent, I concede possibly they may be the consumer, my lord. But the issue is that as on today, for those towers, application has been moved by R4, my lord. Summit District. Now, what we are saying is that against those towers, this much outstanding amount are dues. Please clear those dues. R4 is not challenging my notice, my lord. My case
It is like a buyer of a property.
Yes.
Coming and seeking electricity connection.
Yes.
Where there are dues of the erstwhile owner.
Yes, my lord. That is the precise situation, my lord. And my case is this, that if R4 is not challenging, the petitioner could have challenged that part of the notice or not. That's my simple submission.
My lords, we wish to
R3 and R4 both, my lord.
yes, my lord, we wish to clarify there appears to be a mistake in the learned Advocate General's submissions. There is one error, my lord. Summit Digital wanted a separate tower, not the towers belonging to Reliance Telecom. They applied for a separate electricity connection for a separate tower, not the towers listed in the annexure at page 110. The state said, if we have to give you that separate new electricity connection, you first clear the past use of Reliance Infratel. That, my lord, was what has happened, and that is why I wanted to show page 328 of the representative. May I please have page 328? All of this becomes clear there because this is a new fact that is now coming before you. My lord, page 350, 358, page 358.
Yes.
My lord, this is the representation submitted by the petitioner, and my lords will see the reference. Reference at item number 3 is the impugned demand. I must point out that there was a separate letter sent to Reliance Jio at item number 2, which I will show separately. Now, in that context, may please permit me to read paragraphs 1 and 2. Para 1. We, Reliance Infratel, formerly Reliance Telecom Limited, are addressing this representation pursuant to various communications exchanged between MPTCL, Reliance Jio, and Summit Digital and RITF, and meetings amongst the parties. By way of these communications, MPTCL has demanded inter alia that Reliance Jio and Summit Digital, R3 and R4, make payments of electricity dues incurred on behalf of Reliance Telecom. During the course of the meetings, MPDC officials have communicated that in the event Jio, Summit Digital, RITL do not clear RITL's pending dues, then MPDCL will have to resort to disconnection of supply to towers of the other 3 entities. This is what was happening. It is not like the learned Advocate General said that Summit Digital wanted to take over all Reliance Infratel towers and apply for a new connection.
Does the Electricity Act apply?
In fact,
Yes, my lord.
I'm very grateful.
The Electricity Act says that these dues are statutory dues, my
Supreme
lord.
Court has said, sir, Your Honors, the Supreme.
Yes.
Yeah, I'm very grateful, Your Honor, for that question. The Supreme Court has categorically said that the provisions of the Insolvency Act are paramount and overrule the provisions of the Electricity Act in identical cases. In fact, there is a judgment of the Supreme Court on an identical point that says electricity dues stand completely discharged and Insolvency Act overrides. In an identical case. There are judgments of the Calcutta High Court.
No, that's all right. The tribunal can well say, or the appellate authority, that whether the debt of number 1 was extinguished or not. All right?
Yes.
Suppose it says extinguished. End of the matter. All right?
Correct. Yes.
It can travel up to the Supreme Court on appeal. Now, suppose it says it is not. It holds it is not. Now,
I'm very grateful.
We also hold it is not, suppose. It is not extinguished. Now, then the question will arise that whether for the dues of the petitioner, the respondent number 4 and 3 and 4 having a separate tower. All right.
I'm very grateful.
Now, to what extent, whether yes or no, they would have to clear those dues to operate that tower. That the authority only under the Electricity Act can only determine.
I am very, very grateful for the question.
I do not think the writ court has the power to determine this.
I am very grateful for the question. May
It
I?
has to go through two tribunals, whatever the Supreme Court may have said.
I'm
In this particular case.
I'm very grateful, Your Honors, for the question. Perhaps my senior advocate can better answer that. But may I briefly submit the first from my
If it is
perspective,
extinguished,
what I
end of the matter, nothing. If it is not extinguished, the debt of say rupees X remains.
I'm very
All right.
grateful.
Now with X, now the question is whether 3 and 4 would be liable to pay that in order to operate another tower. Take the case of an Electricity Act. That owner X has dues in respect of electricity with regard to premises Y. Now that premises is sold to Z. Suppose, as you say, 3 and 4 have no connection with the petitioner, separate corporate entities. But this question would still arise whether a purchaser having no connection with the vendor or the seller of the property would be liable to pay the dues concerning that particular property. There the so-and-so does not arise. Whether X is the owner or Y is the owner, it is a property before to get fresh electricity connection. That is the law we have seen in under the Electricity Act.
Yes. Correct. In fact,
There are also rulings of the Supreme Court on this.
I'm very grateful.
Liability, etc., etc.
Yes, sir. Yes, Your Honor. May I assist as an officer of the court?
Now you proceed on your own way. This is just exchange of thoughts, thinking aloud. By myself, you proceed in your way. I will not interrupt you or interfere with your submissions. You proceed.
Your Honor, my lords, may I briefly first, in order to assist the court,
yes,
not specifically on this petition, but my lordships are absolutely correct. If the same property is being used by another user.
So here in your case, it would be whether the separate tower would be linked to the tower used by the petitioner. That's
exactly. That's the difference. And most important, in my case, I have primarily sought for extinguishment of the debt, and the learned single judge has categorically held that the debt is extinguished. So yes, my lords have raised a very pertinent question, and we will answer that. My senior will answer that. But we are submitting preliminarily today the question that is in appeal before this honorable bench is whether the debt stands extinguished in law as claimed by me under prayers A and B.
Yes, yes.
Prayers C is an ancillary question.
Yes. If it is, end of the matter.
If it is, end of the matter.
Yes.
My lord, may I just make a request, because I'm minded that it is already 1 o'clock. Would the honorable bench like to take this matter up after lunch? Because then my senior will also come and be.
No. Well, your senior said that you give me half an hour at 12:30, I'll finish the matter.
I understand.
We have some heart for the court also. We have left other matters and taken up this. So it will be on another day, which is convenient to both of you.
Whatever. I'm deeply apologetic for this inconvenience.
No, you need not be apologetic. It can happen that he is engaged in Supreme Court in some way. You don't have control over that.
I'm grateful. Well, it's tomorrow, day after, whatever is convenient.
No, tomorrow there is two learned judges are not sitting because of some other judicial commitment, administrative. So including my brother. All right, so it can
Monday,
Monday, yes,
Monday. We're very grateful.
12:30.
And
Because
thank you so much.
learned advocate, you must be aware that learned advocate general referred to a judgment of a bench presided over by Justice Indira Banerjee, where
Yes.
22-1 SCC or something like that, where it was said that
Casey Miller.
yes, that where this debt was not included in the debts considered by the resolution professional, the
Rainbow Papers.
yes, it would have no effect, something like that.
Yes, and we have an answer to that. We have a straight answer to that. We will address it on Monday. I'm very grateful for this honorable court to indulge us.
Yes, please. What is your name, please?
Aditya Swarup.
All right, please take it. Mr. Aditya Sarup, assisting the name of the Learned Additional Solicitor General, begins arguments. You're for respondent number 1 and 2.
Respondent number 1, 3, and 4.
All. Which is 2?
2 is the authorized signatory of respondent number 1, Mr. Manish Nath. He was only impeded for that purpose. May take it, I don't think he's directly involved, but I'm afraid, may take it, I appear for him also. He's only the authorized signatory.
Appearing for the respondents. Commences his arguments but does not conclude the same. Lists this appeal for further hearing on 24th March 2025, marked at 12:30 p.m. To be taken up at that time or upon exhaustion of the regular list, whichever is earlier.
May I seek your lordship indulgence to appear through VC on Monday, my lord? Because
Leave is given. Considering the pressure of work of the Learned Advocate General on 24th, as represented, leave is granted to him to appear virtually.